commercial side of evictions and what tenants can do, what landlords are doing, and just kind of give some of those updates. So you can put any questions in the Q&A box or the chat, and I'll be watching those things as we go. And he'll also put his contact information at the end. So Josh, take it away, and thanks for being here.
My pleasure. So again, my name is Josh Borger. I'm an attorney at the law firm of Berliner Cohen in San Jose. My area of practice is business and real property litigation. So I'm going to give you the litigator's perspective of what's happening. I won't start from the very beginning of COVID. That's been quite a mess. If you remember, we really weren't sure what to do, and people weren't sure. The state wasn't moving quick. The feds weren't moving quick. Nobody knew what to do. So that's when the courts come in, and the Judicial Council, who sets the rules for the courts, said, everyone stop. We're not having evictions for X period of time. This gives you, the legislatures, enough time to figure out a game plan and figure out what to do. And no disrespect to anybody, but they didn't do that. There were bills upon bills upon bills, and nothing was getting passed. And finally, the judicial branch came back and said, you misunderstood. We're not legislating. We gave you the time. You can't figure it out. And so this stay is going to be lifted. And that was at the end of August. It was going to be lifted. And so the day before, in a panic, the state passed law dealing with residential evictions, but not commercial. On September 23rd, Governor Newsom issued an executive order extending the ability of local jurisdictions to enact their own eviction moratoriums on commercial evictions from September 30th, 2020 to May 31st, 2021. Now, what did that do? That did nothing, because that's what the local entities were doing either way. So one could argue that he just punted. So a lot of the counties have their own rules, and some came up with no rules. San Mateo doesn't have any rules, either the city or the county, but Santa Clara does. And so let's go over what Santa Clara did do to try to help out. There are rules dealing with small business tenants who qualify if they've been impacted by COVID, and there's an eviction moratorium if they can prove they've been impacted. That's right now extended through March 31st, 2021, which is coming up. I guess we'll have to see whether that is extended yet. Well, as to the best of my knowledge, it hasn't been extended as of today, but that date is coming up, so maybe soon it will be extended. It protects small business tenants because they have up to 6 months after the moratorium expires or terminates to repay 50% of the past due rent, and up to 12 months after the moratorium expires or terminates to repay all the past rent. Now, there are a ton of questions that are coming up with this that nobody has answers to. Does that mean that you can not pay anything and pay on month 50% on month 5, 29th day? Conceivably, it seems like it does. It doesn't say that it has to be paid equally throughout the 6 months or equally throughout the 12 months. So you could conceivably get away with paying somebody the half of it on the 5-month and 29th day, and the other half right before the 12-month expires. So the small business tenants are still obligated to pay rent. But if you can't pay rent due to a substantial loss of income or a substantial out-of-pocket medical expense as a result of COVID, then you can delay paying. So the rent is still owed, but effectively, if you fall into these categories, you can't be evicted anyway. So the rent will be owed at some point, but not now, and you're going to be able to stay there. And so what you should do, though, what they should do is you have to notify, you should notify the landlord as soon as possible. Someone should be notifying you and support it with objectively verifiable documentation. We don't know exactly what you need, but just I've been impacted and that's it is probably not going to cut it. So you're going to want some documentation. If either your landlord or tenant, there should be documents showing that this is what has happened to you. So, what constitutes the substantial loss of income or substantial out of pocket medical expenses? It is really going to depend on the situation. For substantial loss of income, it could be a reduction in operating hours that you need to miss work to care for a family member or a child who's been infected with COVID. Your business had to close. You've had a substantial decrease in income, or some other similar circumstance where you have been impacted and you cannot operate the way you did before, or you've lost money significantly due to COVID. If you can show these things, there's not a fine line here where, and they didn't want to. There's too many factors that could weigh into this. So if you can show that you've had these substantial loss of income, due to your business has been impacted, or you can't go to business because you're staying at home to care for somebody or some other similar circumstance that is due to COVID, then you're going to fall within this, or you should fall within this. Substantial out-of-pocket medical expenses would be for yourself or immediate family members due to COVID-19. This ban applies throughout the entire county, and if you're talking about a different county, the cities can have more stringent rules and ordinances on these. They can't go narrower. If they decide to go narrower, it's not going to matter than the county, but they can be more stringent, in which case you have to fall within what the city is doing and what the county is telling you to do. Some people want to terminate the lease early anyway. They don't think they're going to recover their business ever from what's happening. If you terminate the lease during the time the moratorium is in effect, then all these terms we've talked about, the repayment terms, the protections, all of that, they do not apply to you. You voluntarily terminated. The entire point of the ordinance is there to help you repay it and continue in business. If you've decided you're not going to go that route, then the ordinance is not meant to help you. There's going to be very little that people can answer about the ins and outs of this ordinance because it's also new right now. I've almost given you as much as anyone's going to be able to tell you. It's not been through the courts yet. Like everything else, it was probably done in a hurry. There's probably going to be things like what we were talking about. Do you have to pay equally? It doesn't say that. You can pay at the very last minute, but you can't be evicted. That we're all just going to have to figure out, and maybe we'll never figure out, because by the time it gets through the courts, hopefully the pandemic will be over. Now let's talk about the updates on what's happening for the people who don't fall within the ordinance or who have opted to terminate their lease. These people aren't covered by that. So these people, some of them have said, I'm never going to recover. I want out. How do I get out? And this is where the doctrines of commercial frustration and force majeure that you hear about start to come about. And it doesn't apply in all situations, and it's far narrower than people are giving it credit for. But let's talk about that. Commercial frustration simply means that you entered into a contract, and the circumstances under which you entered into that contract, the purpose of the contract, has been frustrated due to an unforeseen circumstance that was beyond the control of the parties. There is no doubt that COVID-19 is this circumstance that will fall beyond the expectation of the parties. But that in and unto itself does not get someone out of a lease. What I went through when COVID happened was to go back over, because lawyers live by analogies, So I went through case law, going back through World War I, because this is what the judges are going to have to do, and see what happens when, for example, the government prevented businesses from operating due to a different circumstance. And how did that impact the contract or the lease? Those will be the analogies. And we have a lot of historical analogies. So reading those tea leaves, I'm going to tell you how I think this will all play out in the future if people take this through the courts. I've had the call quite a bit where someone has said, they had, for example, a restaurant and they had dine-in service, and due to and let's say it looks like we're opening up, but we may have another surge. Nobody knows. So due to the dine-in, they were not allowed for a long period of time, and in the future may not be allowed to have dine-in. And so could they get out of the lease? Most leases will have a statement of the purpose in the lease to operate a restaurant. Some will be vague and say to do anything lawful in this space that's not prohibited by ordinances. So the fact that you couldn't operate a restaurant, even though it says the purpose is to operate a restaurant, does that get you out? Likely not, because you are allowed to do anything you want with your space unless there's an express requirement, unless it says that you cannot do that. So unless there's an express requirement to open a restaurant, then you can do anything in that space that you want. It's not limited to opening a restaurant. So you could have the purpose in there that says the purpose is to open a restaurant, but it doesn't say you have to open a restaurant. You're not required to have a restaurant. You're not required to have indoor dining. So if you were able under this to do something in your lease, even though it says there's a purpose to the lease that you weren't able to do, then you may not be able to get out of that lease. So you have to look beyond the purpose to state, because I can't do that, do I get out of the lease? I'll give you an example. In World War II, there was a case where someone was leasing a hotel in an area of Los Angeles that was known as Little Tokyo, and they intended to operate it as a business for people of Japanese ancestry. During World War II, due to the internment, they were not able to make that hotel work. They claimed that the government essentially took away their customers. And the court did not terminate the lease. And he said that the lease didn't say that they had to operate this hotel for people of Japanese ancestry. They were just leasing a hotel. The fact that it was their subjective intent is one thing, but the objective contract, the purpose, didn't state that they specifically had to do that. And so they still had the hotel. They just had to market to a larger audience. And so they were not allowed out of the lease. The arguments on both sides of that, if it were a restaurant, and I'm only giving restaurants because that's a good example for these situations. If you are not allowed, if it said you had to operate a restaurant, but it was during a period of time when you could not have either indoor or outdoor dining, then you would have a fair argument that due to the doctrine of commercial frustration, you were allowed to get out of the lease. If you could only not have indoor dining, but you could do something else, you could have outdoor, or even arguably if you could have takeout, as the landlord, you would have a good argument that you were operating a restaurant. It was just not at full capacity. You were still allowed to do takeout. And so that would be similar to the example we just gave. Nobody guaranteed it to operate in the manner in which you wanted to do it. You were still allowed to operate your restaurant a bit differently. And if you had done it right as a landlord, you would say you still could have made money. How this will play out is everyone's guess. But the point here is just because it says a purpose in the lease and you couldn't do that technically in the way you wanted to, does not get you out of the lease. The next situation is going to be the call that I get that people say, well, I had my business, but it wasn't as profitable as before. Some profit because, for example, I had takeout, but I had a restaurant that made very little money off takeout. It was mostly sit-in. And so do I get out of the lease? And the answer is typically no. And I'll give you two examples. Another one from World War II. There was someone who leased an electric advertising sign for a bar, and they couldn't put it up because the government had a rule that they were on the coast that you couldn't have the lights on at night because you were telling the enemy in World War II where the land was. And so the court let that person out of the lease because the neon sign implied nighttime, and if you couldn't have it on at night, you got absolutely no value out of that lease. So, analogizing it to the restaurant, if you couldn't have taken or takeout, sit in, whether inside the restaurant or on the curb, any area there for whatever reason, then the government took all the value out. But there was another case that came down at the same time where someone couldn't sell as many cars as they wanted to because of leasing issues. They couldn't lease the space they wanted, all due to the war effort. They couldn't operate because some parts and some things were being shipped overseas. And the government said, or the California Supreme Court said, no, you were allowed to operate. You just weren't allowed to make as much money as you anticipated. And we never guaranteed you would make all the profit you wanted. You made some money, you just made less profit. So that did not terminate the lease. Analogizing it here, if you can do takeout, but not sit in restaurant, using that analogy, which is good law from the California Supreme Court, albeit from 1944, you probably would not be able to terminate the lease. Now, the other complex situation that comes up is that a lot of leases do have, the big commercial entities have force majeure clauses in there where they'll state that even if you cannot operate, you still owe rent. Some of them will state that if you can't operate and you give notice within a certain period of time, it will extend your lease by that period of time. The problem with arguing that you get out of the lease then is that a contract is a meeting of the minds, and the courts will enforce the meeting of the minds. So if you gave away your right and said that you will still owe and still pay rent, even though you are not allowed to operate due to an unforeseen circumstance, then you will have a very difficult time going into court and stating that you want to terminate the lease due to this unforeseen circumstance because it wasn't unforeseen anymore. You negotiated for it and you decided that you would pay rent under these circumstances. You can always argue unconscionability, which means you were not in a position of bargaining strength and you had no choice but to sign on to this. That is not you usually wouldn't want to be in a position of arguing unconscionability. But if that's all you have, then that's all you have. But I wouldn't expect that to be a winning argument. The next issue that's going to come up for people is they weren't able to operate for 6 months or so. The government then came back and said, now you can operate. And that's fine. But if for a lot of people, you lost income for 6 months, you will never recover from that. And so what happens then? The government saying, come back and operate is not going to help you. This is where there's some authority all around, and this doesn't come up very much, but there is some authority that if you were not allowed to operate for a long period of time, there's no one set period of what that might be. You'd have to argue that to the judge. But that as a result, it took the value out, that you can terminate the contract because essentially it went on for long enough that the contract lost all value. The court will deem something to be a permanent fixture, something that has permanently terminated the contract, even though we all know it isn't permanent. For example, there was a case where a government's embargo on ships leaving American ports during World War II because of the enemy submarine menace was deemed to be an impediment, but the issue was whether it was a permanent impediment or not. And it was actually a permanent impediment. Reason being, everyone knew the war would not last forever, but it had gone on for so long, the submarine menace, where people were not allowed to leave, the ships were not allowed to leave for fear of being hit by you know by a ballast coming off the submarine, that it was deemed a permanent termination of the contract because it had gone on for so long, even though no one thought World War I would go on ad infinitum. The same has held true for embargoes. There was a case dealing with a buyer's embargo, with an embargo where a buyer was trying to buy goods that were being shipped to and from Colombia, the country. And that was excused under the contract because of a government embargo. And no one knew how long the government embargo would last. No one thought it would last until the end of time. But there was an embargo and nobody knew how long it would last. And given that, it was deemed to be permanent such that the contract was terminated. COVID has lasted a lot longer than a lot of people have thought. Whether we are now in that realm of it's gone on long enough, businesses were shut down long enough, either partially due to where you could only do takeout, or you couldn't do takeout, or you just have taken all the value of it. This is a 100-year storm, is what they're saying. So there's a good chance that, or fair chance that a judge would say this constituted, much like a war, the termination of the contract, even though no one expects COVID to be around in 20 years, much like the war. If you can make that argument and succeed, then the contract would terminate. I can't give you more on what the courts are going to do because these issues are decided by the Court of Appeal, and those issues haven't reached the Court of Appeal yet. It takes years to get to the Court of Appeal. By the time it would get there, COVID will have ended. You may have some very long-term leases that are still being litigated, even though the person has terminated the lease, that end up there. And we'll find out maybe in a year or two what the Court of Appeal thinks about these arguments, but no one knows the definitive answer right now. But these are the various arguments that people will have to make when determining whether or not they're allowed to essentially terminate their lease because they don't fall within the exceptions of the county moratorium, or they've decided to terminate their lease regardless of what's in the county moratorium. That was a lot of law for you, I know, but hopefully some of the stories were somewhat interesting. Does anyone have any questions for me? Been going for about 25 minutes.
I haven't seen any yet come in, but please put them in the Q&A and in the chat. Josh, have you worked with anybody recently that is trying to get out of anything, or have you advised anyone yet on this? Or okay.
Yes. And that is where it depends so much on the county that you're in. I've had this issue come up in San Mateo, which is extraordinarily difficult because they have no ordinance. Either the county or the city of San Mateo has not passed anything to deal with this. So the only thing those people have to get out of their leases are the arguments I was talking about, analogizing to cases from World War I, World War II, and an embargo. And you can imagine how comforting that is because nobody wants to be the test case. Santa Clara, at least, we have a little more guidance. There's some problems with the guidance that we have from Santa Clara. I would argue it's not specific enough, but maybe they didn't want to make it more specific. Maybe they didn't want to say that you have to pay your 50% in 6 months in equal intervals. Someone, I'm sure, told them, why don't you say equal intervals? Maybe they didn't want to say that because they knew that somebody wouldn't be able to pay the first month's interval and therefore they'd be evicted. I think I see two.
Yeah. So if a tenant tells the owner that they want to cancel the lease, but just stays in the property as long as they can, what are the repercussions? So that's a good question. I have a follow-up to that.
Sure. You'd want to read the lease to see if the tenant actually does what the lease says to terminate the lease, or I would argue gives notice of termination of the lease that they are terminating it, then they're going to fall outside the moratorium. This is the difference between, it's going to be complex because some people might want to explore the possibility of it without giving notice of it. So someone could say, I was talking to my landlord, I was exploring it, I was seeing if it was an option, but I wasn't actually doing it. The landlord is going to come back and say, no, you actually did let me know you were doing it, and therefore you're outside the moratorium, so I get to evict you. I would be very clear and put it in an email. If you're not actually terminating, I'm not terminating. I would like to discuss this situation with you. Put it in an email and don't be vague. Otherwise, both sides are going to have very different understandings. The one would be they're still within the moratorium, and the other would be you just got yourself out of the protections.
That's interesting. And the reason I'll say that is because we have a small business. Our lease is up in August. So we're starting to look. And I mean, we're paying rent, so that's fine. So hopefully they don't take that as, get them out sooner, and do an eviction for whatever reason.
So the next one I'm reading from Marty. How do people justify getting out of these leases? Well, I don't know anyone, if you're talking about someone specifically, I don't know anyone specifically that you're referring to, but the people who were able to get out of these leases, you're going to want to negotiate something with the landlord. Look, it doesn't benefit anyone to have empty space. The landlord obviously still has to pay the mortgage, and they need the tenant to pay something. The smart way to go about it is going to be for both sides to renegotiate a lease. Either way, they're both going to lose, because if the person has no money, then there's nothing a landlord can do about it. And even if they personally guaranteed it, it may take years to get through the system in order to get any money. And you may find they have no money, even if they did personally guarantee it anyway. It's not going to benefit anyone, in my opinion. I'm a litigator, but to go through the court system on this issue. So how be persuasive with the arguments where it is not written in stone that they're stuck to this lease just because they have the lease. But the other side, the person making that argument needs to understand that it may be an uphill battle to argue commercial frustration and get out of the lease as well. Both sides are going to pay a lot of money in lawyer fees, and it's going to take them a long time to get that answer.
So there's one in there about the different rules if it's a month-to-month versus a long-term lease. Are there different rules regarding any of this eviction piece, or is it the same?
I'm not aware of the county making any distinguishing mark for a month-to-month versus a long-term lease. I mean, it would seem like it would only, if you have a month-to-month, you're not required to give them more time. It would seem like the county's ordinance is limited to the long-term lease. If you can give somebody notice, I would question as the landlord, you can take your property back, but you're not going to find anyone else who wants commercial space right now. So technically the ordinance probably isn't going to apply to a month-to-month, but I'm not sure that's actually going to do anyone any good. What language in a future lease should be included with the possibility of COVID making a comeback? Well, it depends on who you are. Are you the landlord? If you're the landlord, you're going to want to put in there a force majeure clause that states whether whether you're able to operate or not, that you still owe rent. You may want to put in a provision so a judge doesn't push it out that states that for the period you're not able to operate due to an unforeseen circumstance, due to a governmental law or ordinance, that you will be allowed to continue in the lease for that period of time once the ordinance is, or once the law or what have you is lifted. You may not, and see if the judge, I mean, again, if you just agree to it, that you will pay rent during this period of time, regardless of whether you're able to operate or not, you're not guaranteeing anything, then I would argue as the landlord's attorney that, look, this was a negotiation. You didn't have to agree to this. There's commercial space all over the place. You agreed to this. you now still owe rent. I would always have someone personally guarantee it, because these days, if it's just an LLC or other business, the business is going to go belly up and you're not going to have any negotiating room because there's no business anymore. You can't chase anyone. You don't get to go to the individual who operated the LLC or was a member of it just because they were. So you're going to want to state that if due to a governmental law, ordinance, what have you, you're not able to operate, you still owe rent. Tenant owes 5 months past rent for a retail space that's sold online during COVID. Handed over the keys. I want to collect 25,000 rent owed, small claims. I don't handle small claims, but I think small claims is 10 grand or less. 25 grand, I think, is above the small claims amount, I believe.
So the only caveat I'll have somebody test, and I asked this question for residential, and I know they're different, but my understanding is that there is eviction court where you can evict somebody residentially, and that is above 25,000. So maybe look into it to see if there is a way to reclaim that, because this is a very specific situation.
Well, you could, there's no doubt that if, look, pre-pandemic, if you had an unlawful detainer action, I think that's what you mean by eviction court, you can file an unlawful detainer action and then get the property back. So, but that wouldn't be in small claims court. Unlawful detainer actions aren't small claims court. It's the fifth floor of the courtroom that I go to. It's a speedy process. It's meant to be speedy to give somebody their property back, but it's not small claims.
All right.
I heard from you that tenants can still stay for 6 months after the moratorium expires, so they can't get evicted still. Right. This is what they have: 6 months to pay 50% of what's owed, and then a year to pay 100% of what's owed. And so that was the problem. Can they wait until and not pay anything for 5 months and 28 days and then pay the first 50% on the 29th day of the 5th month? There's nothing in the ordinance that would prevent them from doing that. It's not ideal, but there's nothing in the ordinance that would prevent them from doing that. So for example, if someone has 5 months and 29 days and decides they're not going to pay anything, did they get to be there for free? Well, no, because they will still owe. And if they don't pay that 50% in the 6 months, you will evict them. Whether they're able to pay or not is anyone's guess. And so essentially, if they can't pay, then they did get 6 months out of you for free. I have a tenant which runs a hair salon in Los Gatos. Lease has expired, no rent payments. Tenant is trying to negotiate staying until June of 2021. She owes $90K in rent. Tenant wants to pay only $24K and will vacate at the end of the June. Can I still go after her for, okay, I'm not sure this is a COVID question. She wants to pay and will, I mean, the question here is, if the tenant pays a certain amount of what's owed and vacates, can you still go after them for the rest? Well, just make sure that you don't accept a check that says payment in full. Make sure that you don't sign a document that says you don't owe any more. So if they give you their keys back and the lease is terminated and they hand you a check for $24K, can you go after them for the rest? Sure, unless you waived your right to the rest. A lot of people try to be clever and write on a check, payment in full, and then you cash it, and they come back and say, well, we just entered into a new contract. There was a dispute as to how much was owed. I argued it was only $24K, and by cashing it, you accepted that offer. And there is case law on that. So make sure the $24K doesn't say payment in full. And don't sign a document that says. Oh.
I'm just moving. I'm sorry.
Okay. I was trying to read as it was all shifting. I'm not that fast. I think I've answered that one.
Yep.
Okay.
Yes. Do you find landlords maybe making deals, trying to keep, like, as leases are starting to come up, maybe that they're more willing to make deals because they have had a really good tenant in there and they want a good faith show them, like, hey, I won't raise your rent, or let's sign something new, or is it become cutthroat out there?
It's all over the spectrum. I've had matters in LA, San Francisco, Santa Clara, San Mateo, and some landlords I think are playing it smart and trying to get through this with their long-term tenant. Others are trying to push that tenant out. Obviously, they're scared and trying to get whatever nickels they can out of that tenant. I think that is not the smart move because I think they're not going to find anyone else right now.
Yeah.
But there is no
And
universal for how I'm seeing people handle it.
okay. This is more on the sales side question, but we at this moment, I think, are cautioning people who are purchasing a home with tenants already in it. Usually the multifamily and things like that. Are you seeing any issues with people buying commercial property with current tenants, and then all of a sudden the tenant stops paying, or tenants are already behind and someone just wants out of commercial altogether and offload something? Is there anything in that space?
Okay, and just to be clear, we're talking about commercial space right now.
Oh, absolutely.
Okay,
Yep.
okay. So buying a place with an existing commercial tenant.
Mm-hmm.
No, because I'm not seeing so many people that are buying commercial properties right now.
Hmm.
But
Yep.
I'm not in the purchase end of it. I have some of my partners are. They would know the answer to better that for what they're seeing than I do. But I'm not seeing a whole lot of need right now in people wanting to buy commercial space.
Okay. And obviously, are you seeing more of the retail, maybe hospitality, restaurant side struggling more, and more on the industrial is still doing okay with tenants?
Yeah, that does seem to be it. The hospitality industry, dining, everything that made the downtowns, they're just in so much trouble that there's so many of them. I have so many of these cases where I have to advise my clients, unless the lease is personally guaranteed by somebody, if we're the landlord, it's going to be very difficult to collect. If it's the entity that signed up with it, then this is a learning lesson for a lot of people. If it's an entity, the entity can go belly up. And unless you're going to argue alter ego, meaning there really was no entity, it was just a person, which is a lot harder than people think. That is not an easy argument to make. And if it's not personally guaranteed by an individual who has assets, personally guaranteed by someone who doesn't have assets does you no good. You want
Right.
it to be personally guaranteed by someone who owns property, and put in there that they're not going to put a lien on the property somehow. Allow yourself in the contract to put a lien on this property. You want to make sure that they own the property in the beginning of the lease. Do they own it 10 years later? It's a very different question. So you
Mm-hmm.
somehow have to give yourself some interest in these things that are going to be collateral for the potential downfall like this. And I think a lot of people leases are going to be written very differently.
Mm-hmm. So this is Marty. He's a commercial lender. And I guess he's saying that there are still a lot of purchases going on. And it looks like they're reviewing the purchase or the tenant history to make sure that there isn't an issue for a buyer going in.
Okay, I'll defer to Marty again. I'm a litigator. I don't
Right.
deal in this aspect of drafting the purchase and sale agreements. My partners do. So this isn't something that would necessarily come across my desk for what people see when they're purchasing the buildings. I just deal with it afterwards.
Mm-hmm.
Yeah, the Texas judge ruling the federal eviction moratorium unconstitutional. Well, of course, we're in California, so whatever a Texas judge does has absolutely no bearing on us, whether it's federal law or not. I get that we're governed by federal law, but you could have a federal judge in Texas rule X, and it has no bearing in California because we're in the Northern District of California. And so until a federal judge in the Northern District of California makes a ruling on the federal eviction moratorium, then whatever the Texas judge's reasoning was just has no bearing on us here. Someone may take that and try to run with it and get a Northern District of California judge to deal with it. But until that happens, it just has no meaning.
Okay. And I guess my final question would be, obviously there's the moratorium. Are there any loopholes for that? Again, I'm going to go to residential just a little bit, but in residential, if there's a health or safety issue, there are evictions going on. Is that the same for commercial, where there are very specific reasons that you could evict a tenant?
Well, sure. Keep in mind the moratorium only said you can't be evicted if you've been impacted in these ways due to COVID.
Ah,
If you weren't paying rent beforehand, then the landlord's going to say this has nothing to do with COVID. These people weren't paying the rent before COVID. If you're operating a meth lab, it has nothing to do with COVID. I need them out because they're violating federal law, and I'm going to go to jail if my tenant is violating federal law. So I need them out. My property is going to be seized by the federal government. Nothing to do with COVID. This was not meant to say nobody can be evicted under any circumstance. What it meant to say, and what it does say, is if you have been adversely impacted directly due to COVID, and that is why you're not able to pay COVID, then we're going to give you these breaks. But if it's not due to COVID, it's open season.
got it.
The
Yeah,
courts
it
are
seems
open. The courts are open. I was set for a jury trial this morning. They're
okay.
open.
Yeah, the residential side, I think, is where it's more strict, and where you, like, I think in residential, you don't have to show proof at first that you have been impacted, and there's nothing that the landlord can do. And the court, there's the case in Riverside right now where the guy collected his $500,000 and sold his house before COVID, and he's still there, and they can't kick him out. So, yeah.
I've heard of these war stories. I do not handle residential evictions.
Yeah.
The lawyers who do that, that's all they do because it's the same paperwork over and over, and they just keep doing that. So I've heard the
Yep.
war stories. Commercial is a different beast.
Yes, it is. That's what we always tell people. So I don't see anyone. Does anybody else have any more questions? Otherwise, we can give everybody about 15-20 minutes of their afternoon back. If you want, we will send out Josh's email, or if you want to put that in the chat box, Josh, if anybody wants to give you a contact, you can do that.
Sure.
Yeah, we've definitely learned a lot that commercial is much different, and people try to treat them sometimes as one and the same.
Let me put it in 1 second.
There you go. Oh, let me copy and paste that. I'm going to put it to all the attendees too. There we go. So there's Josh's contact information, his email, and his phone number. So if anybody has any questions, go ahead and copy and paste that, and you can give him a contact, and maybe we'll bring you back later this year and see what Santa Clara County has done, and maybe what kind of cases are coming forward.
Sounds great. Everyone, thank you for having me.
Awesome. Thank you.